I would like to say I'm here on special appearance. No, I think I have some rights here. That I'm a living soul. I am not the straw man of the all caps. Okay.
We'll get to that in a moment.
So I am waiving
the time.
I am not waiving any of my rights.
Ma'am.
What statutes or what law or what are you saying here are the charges? Because this does not match. Sorry, I have cotton mouth so bad.
It's really quite simple. When you have an order to show up for court and you turn in a cut up piece of paper of it to say you're refusing to attend, that this is what happens next. That's pretty simple.
Oh, did that offend you? Excuse me. I probably have more degrees than
This Karen sovereign citizen completely lost in court, and it got intense fast. From the start, she wouldn't stop talking, interrupting the judge, throwing around nonsense about not consenting, and claiming she's a free citizen of the land. The judge, in this case, was surprisingly patient, just letting her rant instead of putting a stop to it. I won't spoil everything, but trust me, it's a wild ride. Watch and see for yourself, and think about how you would handle it if you were the judge. I feel bad for the lawyers here. They didn't go to law school for this kind of chaos.
All right, good morning. We are on the record in the 89th District Court for the County of Sheboygan. We're conducting the physical hearing upstairs in the circuit courtroom. It's being clerked by the 89th District Court staff down in that courtroom. And we're here in the case of In re Beth Bridgman on a contempt matter. It was filed in an underlying criminal case 23-0868 SD. We are providing public access both in the courtroom, in the circuit courtroom, and also online. Counsel, you want to state your appearances, please?
Good morning, Your Honor. Paige Miller on behalf of the people.
Attorney Eric Villanueva appearing as arraignment attorney on behalf of Beth Bridgman.
Right, good morning,
also, I will represent myself.
Yes,
okay.
We'll get to that.
I would like to say I'm here on special appearance. Okay. No, I think I have some rights here. I don't know.
What does special appearance mean to you?
It means in a common law that I'm a living soul. I am not the straw man of the all caps.
Ma'am, you'll have an opportunity at a later time. Please just take a seat.
I've never seen those opportunities come back around. Thank you. Okay.
We'll get to that in a moment.
So I am waiving
the time.
I am not waiving.
You can see it on their faces. They're just one deep breath away from losing it. This woman isn't just difficult. She's a sovereign citizen, making every courtroom moment more frustrating. The penalties here are serious. 93 days in county jail, a $7,500 fine, or both. That's the maximum for her contempt citations. Watch it.
Thank you.
Ms. Fitrin, you're free to stand or sit, whichever you're more comfortable with.
I don't know how I would pull the chair up, so thank you.
Well, then, if you want to sit that, I have no problem. All right, Judge Stephen.
Thank you.
All right, well, Ms. Bridgman, you're here for an arraignment on 2 allegations of contempt. So I have to advise you of what those are. The first was an order to show cause that I signed on December 13th, 2023, which alleges that you are in criminal contempt of court for the unauthorized practice of law and for preventing the defendant, Seth Flores, from meeting with the Michigan Indigent Defense Commission attorney prior to his arraignment. We scheduled that for a show cause hearing on December 20th. You did apparently appear in the courthouse that day and turned in a copy of the show cause cut into strips with the red lettering on it. Says your offer to contract is not accepted, and then you did not appear at that show cause hearing. So therefore I signed a warrant for your arrest for that non-appearance. So that warrant alleges that you are in criminal contempt for failing to appear at that show cause.
So
failing to appear for order to show cause on Wednesday, December 20th, 2023 at 11 a.m. for preventing defendant Seth Miguel Thomas Flores from meeting with MIDC attorney prior to his arraignment. So those are the 2 contempt citations pending against you. You have the right to have a hearing on both of those allegations. where your contempt would need to be proven beyond a reasonable doubt. You have the right to present evidence in your own defense and cross-examine and challenge any of the evidence presented against you. You have the right to an attorney. If you qualified and requested, you have the right to an attorney appointed at public expense. The MIDC provides an attorney for your arraignment today, just as a courtesy and as required by a
What is
statute.
MIDC?
Michigan Indigent Defense Commission.
You also, of course, have the right to represent yourself. Do you know? Well, first, do you comprehend the penalties? Oh, I'm sorry, I didn't tell you. So both those contempt citations, if you are found to be in contempt or you admit to being in contempt, you could be punished by up to 93 days in the county jail and or a fine of $7,500 or both. That's the fine. That's the maximum penalty for both of them.
Her. It seems like she's almost daring this to happen, dropping her lawyer, trying to represent herself, and refusing to fight the sentence. These sovereign citizen types really seem to court trouble sometimes. Her playing dumb act is another disaster. Claiming she didn't know better or treating official documents like arts and crafts is not a legal strategy. The judge is left listening to nonsense while she waits.
Ms. Bridgman, do you comprehend the rights that you have that I outlined for you and the maximum penalties I outlined for you?
I think that I would like to wait. I have a call in to the state trooper that your office or the prosecutor's office called to investigate something with me. And I was on the phone with her and told her I had received the show cause. And she said, he can't serve a show cause. I shot over a copy of it. He can't serve a show cause because you're not under bond. This is from the state attorney general's office. I was still on the phone with her. I had filed the paperwork at 9 o'clock. She called me at approximately 10 o'clock. I was still on the phone with her till after 11 o'clock. And she told me that you could not issue a show cause because I was not under bond. Now I understand you have just precluded all of my common law rights by forcing me in the back door into your jurisdiction on this side of the court. And I know that this is not what was on the original document in its entirety. So you have amped up the charges based on the fact that I failed to appear, but I believed she was going to let you know. She was collecting information from me for you.
Waste everyone's time. Honestly, I wish the judge would just take a firm stance, stand up, and have her escorted out. She isn't answering questions. She's arguing for the sake of arguing, interrupting every word he says, and acting like she's in charge of the court. She even brags about degrees and acts like she's ready for a legal battle. Meanwhile, her lawyer is just trying to prevent total disaster.
Ma'am,
Okay, now,
just understand what the judge asked you regarding those two charges.
Did you just understand that I think there's a bigger overriding issue?
But
Thank you.
Hang on.
Thank
I'm
you.
not going to have this.
I'm going to fire him, actually, so thank you very much, because I will represent myself.
Okay. So you're telling me things in defense of the contempt citations, and you'll definitely have an opportunity to present any.
No, because you already,
Hang on, Mr. Villanueva, please stop. I don't want to have this be an argument between
Thank
you
you.
and Ms. Bridgman.
I guess I just like to state that
well, I think we need to back it up.
pleading not guilty to both of those, and that she would like to request a hearing, that she would like to represent herself at that future
Okay.
hearing.
No,
Honor,
but
I
all
just
of my
want to-
rights were strongly impinged upon for even when I never failed to appear.
Okay. We're going to have a hearing where you.
She
can
was
present that.
working, okay,
Okay, you're going to get your
Mr.
hearing.
Villanueva,
No,
I'm
this
directing you to
is-
stop
thank you.
arguing with Ms. Bridgman.
Okay.
I mean, it's a pretty serious thing to have to spend the night in jail, to be brought in handcuffs and everything else. When I was not being belligerent in that regard, she told me that it was not an authorized show cause.
All right. If she told you that, she didn't have the authority to do so. But anyway, that's for the later hearing. So
Well, she was
today's purpose is
investigating.
to-
Okay.
Today's purpose is to advise you of the two contempt citations. So do you comprehend the maximum penalty that those could carry and the rights that you have that I outlined for you?
Now, can I ask what statutes or what law or what are you saying here are the charges? Because this does not match. Sorry, I have cotton mouth so bad. This does not match what the previous document was that you sent to me, and I have a picture of it on my phone, but my phone's not with me. Okay? It does not say.
I've told you the charges. I don't have to answer further questions about that from you. Do you understand the rights that I listed for you and the penalties?
Why have they changed,
I'm
Judge
not
Gaffney?
answering that question.
Can the prosecutor?
No.
Why?
I need an answer to my question. Do you understand that? So you said you want to represent yourself, right? Do you wish to represent yourself and not have an attorney represent you?
Yes,
Okay.
I do.
If you want to do that, I must establish that you know what the penalties are and what your rights are. And I have to establish that you're not going to be disruptive to the court. If you refuse,
So are those?
if you refuse, then I'm going to appoint
I'm not
an attorney for
refusing.
you. Okay, then I would appoint an attorney for you and you'd not be able to represent yourself.
I know. I listened to that with Trevor's case.
All right, so I'm asking you, and you saw what
How
happened.
can I do?
Pastor. She's wrong about the court orders, too. Just because she wasn't on bond doesn't mean she can ignore court supervision. Every document is just another coloring page to her. It's clear she thinks representing herself is fun, like a game. But this is court, not a playground. She seems genuinely confused about the process, acting like she's about to be sentenced when this is just an introductory hearing.
I first have to make sure you know what the maximum penalties are and what your rights are. Do you not?
Those maximal penalties are based on the charges, and I'm wondering how you arrived at a change in the charges.
I'm not answering that question. You know that you could face up to 93 days in jail and over $7,500 fine. You understand it.
Up to that. Okay, but I don't even understand what the charges are.
Okay. And do you have any questions for me about any of the rights that I listed, that you have to have an attorney and have a hearing and present evidence? Do you have any question about any of those rights?
I have a whole question about the whole context of everything today, Judge Gaffier.
It's really quite simple. When you have an order to show up for court and you turn in a cut up piece of paper of it to say you're refusing to attend, that this is what happens next. That's pretty simple.
Oh, did that offend you?
No, it did not offend me. It was a contempt of court.
It's a
It's not
common law
about
thing.
anybody's personal feelings. It's about the authority of the court to compel appearances, and you did not appear. So I do believe, based upon your answers, that you do understand the maximum penalties that you face and the rights that you have. So, Ms. Bridgman, Mr. Villanueva indicated that you wish to plead not guilty to those charges of contempt. I gather from your comments that you would agree that you're not pleading guilty to those, correct? Okay. All right, so we'll enter a not guilty plea on your behalf to both contempt citations. We'll schedule this for a hearing where the prosecutor will present evidence, and you can present evidence in your defense. If you want to have an officer come testify on your behalf, you can certainly do so.
I would like to request a trial by jury.
There is no right to trial by jury in a contempt matter. So
Oh.
that request would be denied.
Okay, so then there's no chance to understand what you're charging me with prior to this hearing.
I've told you what you charged. I can read.
To explain charges. Is she pretending to be clueless? Or is she really that lost? Probably a bit of both. She doesn't understand that the Constitution allows states to make their own laws. Michigan, for example, uses this authority to create its legal codes and procedures. Following state law isn't ignoring the Constitution. It's exactly how it works.
I don't see where there's a code or a statute or any law that I have actually violated here.
Well, that's not required to be on a contempt citation. I've told you what the allegations are. If you want me to read them to you again, I will.
Okay, and the contempt charges that you're saying have changed from the first time.
No, there are two. One is the contempt for unauthorized practice of law and preventing Mr. Flores from meeting with his MIDC attorney prior to his arraignment. The second one is for failing to appear for the show cause hearing on that contempt.
So I only show one now.
What is
Okay.
what one you have?
And this is preventing. And how did you arrive at this at a later date than to issue a bench warrant?
Mr. Villanueva.
There's two items checkmarked here.
This is after the fact. So then you added a different charge than the previous one about the same date.
Ma'am, he read two charges. There's two charges marked here.
Excuse me. I probably have more degrees.
And here's the irony. She rejects government authority, but happily collects disability checks every month. Some contradictions are just unbelievable. Overall, this was a wild courtroom scene. The judge could have been stricter, but maybe he wanted to stay calm on the record. It's amazing how people think shouting Constitution makes them immune to state laws.
All right.
Now,
I'm going to find that,
please, Judge Gothier.
sure, go ahead.
Thank you. Okay. So the first one was that I was practicing law. That was the first one. That's the show cause that you say I failed to appear for.
No, it was contempt for unauthorized practice of law and preventing defendant Flores from meeting with MIDC attorney prior to his arraignment. That was on the original.
No, I have a picture of the original one. This is why I'm not sure.
Do you have a copy of that show cause in front of you right now or no?
This one.
Would Your Honor like to see what she has
But-
here?
I just, so if
Okay,
you don't.
so how do I defend?
Hang on. If you do not have in front of you right now a copy of the first show cause, I'm happy to provide a copy to you.
So how did you arrive at a second show cause?
Because you didn't show up. The second show cause is for failing to show
But I wasn't on bond. So both show causes are not in effect because I'm not on.
When in reality, the Constitution gives states the power to enforce them. What do you think about this Karen's sovereign citizen? Was she just playing dumb or genuinely confused? Drop your thoughts in the comments. And don't forget to like and subscribe for more real courtroom drama.